You're listening to Off to Market with Scott Farley and Hamish Chadwick.
I'm Hamish.
I'm Scott.
And today we're talking to Regan, and this has been Scott's contact for a while with regards to patents. So Scott, I'll leave it to you to introduce our guest.
No problems. We've just caught up with Regan. As I said, as Hamish said, we've been doing this for a long while. And, with me, good suppliers, I capture under my wing and don't let them go. So poor old Regan's had to deal with me for a long while now. And Regan's just become part of Spruce and Ferguson, but previously he was with Cullens, and so I consequently parked at the wrong end of the city and had to walk all the way down catching up. But the good news is we're up here in the clouds at Spruce and Ferguson.
Podcasting is great for exercise.
Yeah, that's right, and we don't have the bugle horns and the sirens going past that you have at my office. So that's sort of, I guess, our relationship in a nutshell. But Regan's one of those sort of people who, in an industry, shines out a little bit. He's basically got a lot of insight and a hell of a lot of knowledge about the industries. That's why I've sort of chosen him to have this little interview, because I'm hoping in this a little mystical area that some people are going to really get a lot out of this podcast as far as what to do and what not to do with patents. And so I might just start it off. The biggest thing I always get is everyone says, I've changed it by 10%, I can now do my own patent. Did you have any comments about that, Regan? Because it's one of those things that's a massive misconception. I get lawyers telling me it, I get all sorts of educated people telling me they can change their patent by 10% and they're going to be able to do another patent based on the same idea, and it doesn't work that way.
No, look, depending on how or who you talk to, that's a 5% rule, a 10% rule, a 20% rule. The number varies, but it's always if I change it by X%, can I do something? The rules with the percentage, there is no percentage change. That rule or that number sort of comes about because people look at it and say, if someone's got a patent, it's normally the other way around. If someone's got a patent and I change it by 10%, I won't infringe, which is that's not even the case. So patent infringement is all about, and sorry, I say patent and patent. I say them in the same sentence.
At least you don't say patent.
I don't say patient.
I've got people say patent, and it drives me nuts.
People ring up here and go, I want to
patent.
patent my trademark, and you go, oh, hang on. No. IP's all about jargon, but yeah, patent and patent are the same thing. It's just whether it's English or the US. So Australians tend to say patent. Yep. And the US says patent. I say that
there's no I in the word. It's not paint.
Patent. No, there's no N before the T either. I say patent and patent in the same sentence interchangeably. It doesn't really matter what you call it. Just PATENT, patent, patent. Anyway, sorry. The infringement rule. So the way patents are written is there's a thing at the back called a claim. The claim sets out your scope, if you like. That's what your protection is. The claim is written as a list of features, so it's normally a widget including features A, B and C. Someone will infringe that claim if they copy each and every essential feature, in inverted commas is the legal jargon. So basically they will infringe that patent if they copy features A, B and C, if that's what the claim says. Now if they copy A, B and C and add D, they've still copied A, B and C, so they still infringe. If they add D, E, F, it doesn't really matter. They've still taken A, B, C. So that's the definition. That's how infringement works. You don't infringe a patent, and this is where this percentage change comes in. You won't infringe a patent if you take A, B, and not C. So if you leave something out. So people often get caught where they go, oh, I've done this, I've copied their product and I've added this. That doesn't work. So in order to avoid infringement, you have to leave something that they've said is essential out. And generally, I mean, that's what a patent attorney's job is. When we're asked to write patents, you're asked to basically provide the broadest scope you can by reducing the number of features that are claimed to the bare minimum. So people come in here and go, I've got a patent for a table with adjustable height legs. And you go, well, you actually don't have that. The broadest you can go on that is probably just an adjustable length assembly, which you use as a leg, but equally that could be used as, extendable pole for your pool tool and all this sort of stuff. So we get paid basically to broaden out everything and reduce the number of features you've got in your claim to make it as hard as possible for people to design around.
Yeah, and that's one of the areas I've noticed you're very, very good at, very broad. We do unique products, so generally it's a first of world, that's my niche, first of world, 100-year change type product. So it's sort of a little bit easier to make those broad. When you're doing something that's sort of a Me Too type product, which means it's already out there in the droves and you're doing a similar sort of thing in a different way, then it's a lot harder to make them broad. Let's just step back a little bit, because we've talked about patents, but we haven't really defined what a patent is. So a patent is basically, obviously something that's novel and has an inventive step, and that's the two criteria. And there's also obviously design registrations, and I think from my experience the 10% thing comes in there, because a design registration is about the shape and configuration, which is just simply the way something looks. And when you change that,
it's a lot more fluid.
You don't have to change that by much to be able to have your own option there. 10% is probably ample. And I think this is where the confusion might come about.
I mean, it's hard to define what 10% of anything really is. But so, patents 101, IP 101. So patents protect function. So it's the features that do a particular job or allow something to do a particular job. It's normally a set of components. You can patent methods in a set of steps that allow you to achieve a particular outcome. Methods are a lot more difficult now, particularly a lot of people are in the computer implemented space. Every second person that comes in here has an app. Apps are difficult to patent because patent offices around the world just don't like apps at the moment. Software implemented stuff is difficult, but unfortunately that's where a lot of the development is. So patents are very functional. It's how does it work, what does it do, what are the features that allow it to do that, and then you protect those features. Designs are exactly as you say. They're a form of protection for the visual appearance of something. So they don't cover how
you have a cup and you've got an oval shaped handle, and you have a cup with a triangular shaped handle. They both separate identities, even though they're the same function.
So designs are useful, and they're good for things that have to look a particular way to work a particular way, or they're equally good for things that are known but look different. So chairs, bottles, a lot of that stuff gets design registered. You have design registrations for the patterns on floor tiles. You can get design registrations for fabric patterns. So they're very they're useful for the things that fit them well. So visual appearance protection.
And sometimes that's really important for your brand identity. Obviously Hamish is a brand, so the way your product looks, if it's an engineering product, there's no paintable aspect about it. You'll still get a design registration because you don't want someone else to come out with the exact same thing in the exact same look, because that's your identity of your product. They can do it a different way and look a different way. With patents, what I normally do if I have to get around a patent, so if someone comes to me and they've got an idea and it's worth pursuing and there's other products on the market, what I try and do is, my list of criteria is to do the same thing in a completely different way. So there's always more ways to skin a cat than one, and
that's functional again. You're going to the function of it.
Exactly
I want to do that job, but I want to do that job in a different way or using different parts, and that's where, like when we were talking before about the 10% rule, if you're different enough, you can get a patent over someone else's patent, provided that you're functionally different, or the way that the parts work together is different, or the parts are different.
And that's also really why it's so important to get a really refined product on the market, because if you can make it as cheap as possible and as efficient as possible, and you can patent that way of doing it, if someone else wants to do it a different way and it's more expensive, you're going to have trouble breaking into the market, which I guess comes into what products to patent.
And what and when are possibly the two questions that we get asked the most. And the Cliff Notes version of it is, yes, you can file stuff too early. Like a lot of people come in here and they've just got a drawing on a page and they go, here's my invention. You go, you don't really have an invention. You've got this nebulous sort of concept in your head that needs a boatload of work before it's actually going to be a marketable product. And if you do that, if you come at that stage, what your attorney should be saying is, you've come too early. it's good that you're thinking about it this early because that's the right time, because you have to file a patent application before there's any public disclosure.
Yep.
But you're too early in the process.
Yep.
You need to do some work to flesh it out, to get as far as you can toward the finished article.
Yeah.
I mean, the closer you can get to that finished article,
More powerful your patent is.
the better the patent can be written. The cheaper it's going to be in the long run, rather
Easier
than
to
writing
defend.
4 or 5 things that arguably cover it or may cover it,
Yeah.
and then you come up with something completely different by going to someone who knows what they're talking about in the design space, like you guys.
Yeah.
It might change from the back of the envelope picture to the finished product. That's ridiculous how much it changes.
Yeah.
So you're far better off to get as close as you can to the finished product before you start.
Yeah.
That's the first thing about the when.
Yeah.
And then the what. I mean, that also clarifies what you're trying to protect.
Exactly.
Because you're not going to get a patent for something as broad as a picture on a page. This is my my new brick that is going to become the world leader because it's made out of low carbon footprint stuff and has an interlocking key that allows it to lock together with other bricks. And you go, okay, that's fine, but there are a myriad of interlock key things around. How is yours different? I don't really know. Well, go away, do some work, get some input from someone to help you design this thing, and then come to us with what the invention actually is in a little bit more concrete form. Sorry about the pun. You need,
We want more puns in this
more
podcast.
more perfuns. I mean, as far as you can get to the finished product, that clarifies. That gives us a when
Something
you're
to document.
filing
Yep.
and what you're filing. Like it's much easier for a patent attorney to say, we're trying to protect this.
Yep.
If the thing that you're trying to protect is actually in a finished form,
Yep.
then you can direct the protection a lot more focused
Yep.
instead of just shotgunning everything.
I mean, there's obviously this whole. Sorry.
I was just going to say, just also for in terms of a patent is all about protecting an idea, protecting a product, protecting a concept.
Yep.
Now, if you haven't got a patent and you're starting to talk to someone like yourself, what protections can you put in place to guard your idea if you've told someone to go away and work on it,
Yep.
they've told you, they've obviously told someone else perhaps. What sort of protections would you recommend
Yep.
at that point prior to having a patent?
Yep, no problem. Look, patent attorneys are governed by a code of conduct that's very similar to the solicitor's code of conduct that says we're not going to abscond with your IP, blah 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 blah. I mean, Cullen's, the predecessor to Sprucen's, was around for 80 years. Spruce and Ferguson's been around for about 130 years. You don't stay in this business if you start ripping people off their idea. Most patent attorneys will be happy to sign a non-disclosure agreement, and non-disclosure agreements are everywhere. We have one. I think we've all got our own one in this office, and they all differ slightly, but they're also the same thing. I, being the discloser, am going to show you, the receiver, information about blah. And normally in the non-disclosure agreement, there's a single line, which is not particularly helpful. The best way to fill out a non-disclosure agreement is get together everything you can about what your invention is, staple it all together to the non-disclosure agreement, and on the line in the non-disclosure agreement say, information in relation to my invention, as attached. And then when you get the person to sign the non-disclosure agreement, get them to initial the pages, because the problem with non-disclosure agreements, what you have the argument with non-disclosure agreements is always about what was disclosed. So if you've got as much as you can in a pack, and the person signing it, the receiver, initials those pages, if you ever enforce it, you stand up in court and you go, right, we've got a non-disclosure agreement. No. Yeah, is this your signature? Yes. Is this your signature? Yes. Is this your signature? And they're just turning pages saying, is this your signature? Yes. So all of this stuff was meant to be kept confidential. Yes. You basically shortcut the whole procedure. So use non-disclosure agreements. Most patent attorneys will sign them. Most people who are aware of IP, so the design fraternity, accountants, lawyers, any sort of professional advisors are going to be fairly comfortable with a non-disclosure agreement. You can download them off the internet. You put in inventor confidentiality or non-disclosure agreement, you'll get hundreds of them. As I say, they all say the same thing though. You want a short one because if it's too long it intimidates people, and most of them are a page. if that, with signatures on the back. So use non-disclosure agreements. That's the way to protect it. The other way is, you walk into a meeting and you have a bit of bluff value if you say, I've already seen my patent attorney. In all of these things, dealing with patents, it's the IP industry in general is very difficult to understand. A lot of people don't know what they've got, they don't know what they can do, and in a lot of these cases, uncertainty is your friend. If you can create uncertainty about what you've got, then someone who's looking at copying might just go, it's too hard. I don't know what I can do and what I can't do without getting in trouble, so I just leave it alone. Yeah. So if you can create some uncertainty, and a lot of people just ring us up and go, is it okay if I say, it's in the patent attorney's hands? I'm fine with that. You've spoken to me? Yep. If it goes ahead, you'll engage me, that's fine. You've spoken to somebody, feel free to say, I've spoken to my patent attorney. And people go, okay, they've at least got enough knowledge about it to be talking to a patent attorney, so what can I do, what can't I do? Has something been filed? Has it not been filed? It's that uncertainty thing again. It's, but use non-disclosure agreements if you're talking to anybody, right? Because that is important.
Right. Let's just swing back to, we were talking about when to patent. So we've got a little bit distracted, but we hadn't quite finished off there. Very important little fact here. Patent attorneys are sort of obliged to get the cover in place early, because if someone else comes along and does the same thing, the client comes back and goes, you could have got me in earlier. My opinion is the same as yours. If it's not resolved, it's not worth patenting. It's basically not worth the paper it's written on. It can't be defended. If you have a date in place where the provisional was a sketch on the back of a pad, and then a year down the track you've got a resolved full patent, if it went to court, you go back to the original date and say, well, this is what you had covered as a sketch, and it does, shows a string going to the moon and some sort of transportation method up there. It's never happened. So for me, I get to a working, proven prototype before I patent.
I had that conversation with a client or a prospective client the other day who sent me information and said, can you file a patent on this? And I said to her, yeah, you can, but the patent document itself is a disclosure document, and whatever's in that document when you file it gets a certain date. So if you're back of the envelope and you file a document based on the back of the envelope stuff, what you've got cover for in that first patent and disclosure for is the back of the envelope stuff. What typically happens over the first 12 months is you undergo some development, and within that 12 months, if you get to a product or a designed product, then it's going to be much more detailed than the back of the envelope stuff. So what you do then is you might file another patent application that discloses the product. The problem is that any information in that second one that isn't in the first one gets the second date, not the first date.
Yeah.
And that's where people run themselves into trouble.
That's a bit pointless.
It's not set and forget. You can't just go, I've filed something that's really broad and I'm covered. You need to look at it as a, the when question and the what question are related.
Yep.
When you file and what you file determines what you get. So the best form that you can get it into before you file your patent, even if it means waiting a little bit longer, the better you can make that application, the more complete you can make what's the disclosure in that document, the better the patent's going to be, the better the cover's going to be.
Well, and we've had a classic example with the click sinkers that we did through you. That's a product I do that's just a replacement for normal sinkers that snaps on and off. And there was one cross section we didn't put through in the drawing. I didn't put through in the drawing, my fault. But we did the patent searching. We didn't find any opposition to it that was sort of going to give us problems. And then when it got examined in America, the only country that got a question on was America. And there was a product in there which the insert came in and out of easily. And we didn't have one cross section through. We went to apply with another divisional just to cover that one aspect. So it has to be pretty precise with a pretty serious set of drawings defining exactly what the product is to be really, really strong.
And it's getting more like it used to be that you could file a waffly provisional and you'd still be entitled to claim that date. The Patents Act changed in 2013. They really tightened up on that. So now there was a requirement before, but the requirement now is called support. So whatever the patent application ends up being, you're only entitled to the date that information is supported
Yep.
for. So if you file that early wishy-washy provisional,
Yep.
and then you file the detailed one later, you're going to get the detailed date because that's when you have the support for
Yep.
the things that you're trying to say.
Yep.
The wishy-washy one you're going to lose.
Yep.
So you can file too early, and a
Yep.
lot of people do.
So what we've always done very well together, because I deal with startups and inventors, we've always used, and I appreciate this because a lot of IP attorneys will not allow you to do provisionals. They really want to go straight to a standard. And there's two reasons we don't do it. There's a commercial reason, and obviously the fact that it hasn't resolved enough to be worth the paper it's written on.
Yeah.
So what we do, we get to a working prototype that we're very happy with. It has to be almost market ready before we put a provisional. That's my advice to clients. They can do what they want. I just give them advice. I can't tell them to do either, because I wouldn't want to be the person who says don't get cover and then get beaten to the mark. So you've got to weigh that up. But this is your information. There's a good reason why it is silly to go early. But what we do is we run the provisionals, which are unpublished and unexamined. So basically you can run the provisional through with a level of cover.
Yep.
Until you've got your adapted part, and then go to a full patent, and that works very well. And the reason sometimes we run provisionals longer than probably other people is because if you've got a situation where you're trying to commercialise a product and you've got all your development costs, which you've just paid for, you go to do your provisional, which is around $5,000, so relatively cheap in the patent scheme of things. And you also may have coming up your tooling costs or whatever commercialisation costs, which are all big things to account for. You don't really want in that timeline to have your standard applications or your international applications coming through. So sometimes if we have to, we'll go to a PCT, which is the Patent Corporation Treaty, which allows you to have 250 countries, options for 250 countries.
155 in the PCT.
I'm sorry, 100 now.
Yeah.
But a lot of countries that you can then, in 18 months, pick and choose from. So that'll delay the process to the point when you've got your tooling and everything paid for and you're starting to make money, and then you can afford those things, or you've got your deal in place. So it's very important, I think, in my mind, not to rush into patents because you may end up finding that your tooling and your big costs are coming in at the same time your patent costs are coming in, and it can break companies financially.
You want money coming in.
You need money
to
coming
pay for the big
patents.
costs. Yeah, I mean the patent system is set up so that it's relatively easy to access it at the start. So the provisional is, as you said, it's about $5,000 to file it. It gives you 12 months of rights in about 190 countries around the world. Not published. People can see that it's there, so they can see that it's been filed. They can find the title, but they can't read the document, and it's easy to update. So that's its strengths. But once you've paid your $5,000, you basically pay nothing for 12 months if you want. Then you can file that PCT application, which is probably more expensive. It's about $10,000 or $11,000 now, I think, to file that through an attorney, and it gets you another 18 months in about 155 of those 190 countries. So you can get 2.5 years for about $15,000. So you're sitting there in your 2.5 years. Your job in the 2.5 years is to start making money, because at the 2.5 year mark, you're going to start to see serious cost if you're choosing a number of countries. The US is $7,000 to file. You can cover Europe as a whole. Even post-Brexit, you'll still get the UK because it's slightly different in the patent world. But that's that application's $15,000, $16,000, $17,000 to file. So you do those two countries in Australia, you're at $25,000, $26,000 straight away,
Yep.
filing cost only, and then there's examination and other stuff down the line. So the patent, they realise that it's expensive, so they've set it up so that you can get these blocks of protection, 12 months at the start, and then if you want another 18 months, relatively, it's not cheap, but it's relatively cheap for the cover that you're getting in the geography. Yeah. So you get that cover, and your job in that time is to start making money, because you need money coming in to fund those downstream costs, because they are substantial. And if you've got no money coming in, my fear is people ringing up saying, "Oh, I want to file these national applications and I've mortgaged my house." And you go, that is a dangerous situation.
Exactly.
Very dangerous.
Yes.
So the sooner you can get money coming in for this from sales or licensing of the product, the better it is, and then you can use that money to fund the ongoing stuff. You need to treat it like part of our job is to take the emotion out of it as well.
Yes.
You know, we understand that it's your baby, you know, that sort of stuff, but you need to be realistic. And one thing your patent attorney should be saying to you is, you know, are you sure you want this many countries? You know, can you fund that many countries? Is there money coming in to pay for that many countries? Because otherwise, it's just shooting in the dark. You know, potentially wasting money. It's just, you know, it's a terrible situation. It's not good for us, and it's not good for the inventors or the funders of these things either, because it just ends up everyone's disappointed because it could have been something and it's not achieved its potential.
And not forgetting that you might have developed the best solution for the product, but does the market actually want it? Until you go and put it on the market, you're not really sure whether you're going to have an income.
Are they going to buy it?
You don't really want to be tied into international patents.
But also, just to clarify, I mean, you have to, just because you've got a patent doesn't necessarily mean that's it. No one will copy it. I mean, if someone can copy it, then you've got to pay for the defence of that patent. Is that correct?
People are. It's human nature. People are going to copy stuff that is successful. If you're making money, then someone will want to copy it because they can see it and they go, he's making money out of it, and it's easy for me because I'll just buy one of his and reverse engineer and start making it and selling it, and I don't have any of their costs except their manufacturing. I don't have any R&D costs because I've done all the work. So people will copy stuff if it's making money. They don't copy stuff that's not making money because it doesn't make any sense. But if you become a success, that's when you get copied. And I mean, the patent gives you the right to chase them and the ability to chase them. It doesn't mean you're automatically going to be successful. And that guy's not going to roll over just because you say, I've got a patent and you wave it around. So you're still, most of the time, if they're invested in it, which they generally will be if they've tooled up to start copying it or paid someone to tool up to start copying it, they're invested in it, you know, at least to some extent. They're going to defend anything that you throw at them, so it's going to start costing money. And Australia is an expensive country to go through IP litigation. It's one of the more expensive places to sue people in the world, just because of the way our legal system works.
It's definitely one of those, it's like product development. You got to build it on rock, because the stronger that patent is, the less likely someone is to go and take you on. If I look at a patent that's been scribbled on the back of a cut post-it note and submitted, I'm pretty sure
you're more confident.
You're much more confident about
tell.
saying, well, is this going to be a defendable patent or not?
You can tell.
You know, if you've drawn it up correctly, you've had it fully resolved, the product on the market's in the drawings. You know, this is going to be hard to get around. I'll go and make money another way.
I'll follow the path of least resistance,
especially if they're a multinational. They go, well, that would be silly for me to do.
And that's where it's useful. You can talk people out of it if you like before they even start. By sending it to them, it's clear that it's relatively good. They go, okay, I'll just focus elsewhere because it's easier.
But we've been focused on patents and a little on design registration. There are other levels of cover, but we won't go into the other ones. There's plenty of information about trademarks and copyright and all the rest of it on the IP Australia site. But the patents is really our area. You know, it's something that we do. And another question that always comes up is China going to rip me off? And my experience is that Chinese patent system is very, very strict. And in the last 10 years, they've done a hell of a lot to bring that to an international standard. I don't see Chinese ripping stuff off anymore. I see Australians using Chinese companies ripping Australians off. But
that's typically how
Chinaman, but poor Chinaman has no idea what he's doing. He's just following instructions.
He gets engaged to make something and he makes it and provides it.
So from my limited knowledge, the penalties over there are very, very high. The idea was the Chinese government saw that people it was a restriction to their trade because people were saying, well, China ripped me off, I'm not going to go there. So they just changed that. You know, as you do as a dictator, you say, this is not happening anymore.
It's much easier when there's
big bad
one
trouble.
boss.
And it has, and it's so very powerful. And from what I hear, the Chinese are patenting a lot of stuff.
The Chinese, the Chinese system is the most used system in the world. So there are more patent applications filed in China than probably the other top 10 countries in the world combined.
Wow.
It's ridiculous.
That big, yeah.
And that comes from every 3 years the Chinese government institutes their 3-year forward plan, and their 3-year forward plan for the last 10 or so years has included this IP focus. So Chinese companies get incentivised now to produce their own IP and then file patent applications, so the government actually reimburses them some of the money for the patent applications they file.
Be nice, wouldn't it?
So that's why it is
government.
the most used.
Are you
It's
listening?
crazy.
You got until Saturday.
That was the last election when Malcolm Turnbull was talking about innovation, and then it all disappeared from the vocabulary. I don't know where it all went, but hey, we'll stop there.
They've still got some good stuff going on, I
Yeah.
must admit.
True.
So
China-
they're strong now. They're strong.
Yeah, look, and it's a historical thing. You got to understand the development in China. It used to be easier for them. They used to make money out of the copying,
Yes.
whereas now they're trying to turn themselves into a manufacturing, an IP hub, if you like,
Yeah.
a respectful. They respect IP there
Yes.
now because they're producing so much that's going out,
Yeah.
and foreign countries have said, well, we're not going to.
No.
Why should we help you with yours if you're not helping ours with in China?
Yeah.
So the Chinese system, though, is very different to Western systems. Their driver is on stopping infringement, not reimbursing you for the loss. So in Australia, if your patent's infringed, you can claim damages from the person infringing. You can say, you made X amount of profit out of it, and I want a percentage of that X amount of profit. So there's two different ones. There's damages, which is the damage you've suffered, or it's an account of profit based on what they've made. So they're the alternatives. But it's based on reimbursing you in effect for the loss because that person infringed your patent. In China, completely different. The Chinese system is based on stopping the infringement. So China was one of the first countries in the world to have IP police. They basically drive around and they break stuff, or they burn stuff, or they shut people down. It's also enforced at a regional level rather than a federal level. So if you've got a patent in China and it's being infringed in a particular province, you register your patent with that provincial government, and the provincial government actually enforces it. That's the better way to do it. You can get countrywide legal judgments in China, but they're slower and difficult to get. It's much better to enforce at that provincial level because they're a lot more mobile about what they can do. And basically, they just go, well, is this guy infringing or not? Yep, send out the IP police. And they just they drag stuff into the street. They'll take it away. They'll break machines. It doesn't stop the guy setting up next door the next day. But it's going to cost him money to do that if they basically just sledgehammered his moulds or something like that. So it's designed to do that rather than reimburse you. So it is a slightly different thrust, but they are getting much better with it.
It's only relevant, I suppose, now for this, not for this podcast in years to come, but Treasury Wines versus Rush Rich with the Penfolds copying. That was, I believe, a reimbursement. I don't think they smashed bottles of wine. Is that true?
Yeah, look, you can get. There are damages awards over there, but the damages awards are much lower. Like you read about the awards of damages for patent infringement in, the BlackBerry case in the US in the early 2000s. That was hundreds of millions of dollars worth of infringement. Whereas in China, it's tens of thousands US. It's just not at the magnitude that it is everywhere else. Like even in Australia, you can get millions of dollars worth of damages, whereas China just doesn't have it. They don't have that.
No.
The Chinese thing is interesting, particularly that Penfolds thing, and this sort of deviates a little bit, but just on trademarks, China is a first to file trademark country. So what that means is whoever files the trademark application first gets it
In China.
Regardless of who actually owns it. So one of the difficulties that winemakers have historically had in China is they have an anglicised, like Penfolds. They use Penfolds as their brand. So someone in China opens up, Penfolds wines, but it's not Penfolds. It's I can't even do it. I'm not even going to try to do it. But it's Penfolds in Chinese characters.
Yes.
And then they register Penfolds in Chinese characters, and because it's a first to file country, they own that. Penfolds it's very difficult for them to get that back. and it can be very similar or sound very
So
similar.
they can't argue prior use.
No. So
Right.
in Australia, we have that prior user right, where I used it first, you apply to register it, I can oppose because I've used it before you and I have a reputation in it. So I have some protection. In China, completely doesn't exist. So trademarks in China, you've got to be very careful, and you've got to file them early, because if someone sees it when it's popular and says, oh, they haven't taken steps to protect their rights in China, file it, it's very difficult to get that trademark back.
That brings me to another point, which is I'm honest here, and it may be one of the myths, but you'd be able to tell me. A lawyer told me at one point that if you have an idea, you take it across to China and they develop the solution, their law supersedes the patent. So they basically, the country owns it, or the person who developed it owns it above the patent right. Is that correct or incorrect?
Look,
Because this is an issue with me. I always try and get everything developed here because I make money at it. No, but I do see people going over there with an idea, and it's very, very hard to go with the idea. They're very good at reproducing things, but not so good at
solutions.
So it's very tempting for people to just scoot across to China with an idea and say, I'm just going to get it made, but I see it always ending up in tears. So there's another side of it. If it's not going to give you any patent protection, there's another side of it as well, because obviously now with China being so developed and having like nearly 300 million
customers, potential customers,
middle class people there to buy stuff, very influential. They're actually competing with Americans. But I actually first time now actually recommend people get a patent in China.
the value
there.
Yeah.
Yeah.
It's all about customer base.
So it's very important to make sure you have if you are developing something, you have the IP.
You always sign those. In the absence of an agreement to this is the golden rule. The golden rule. In the absence of an agreement to the contrary, the person who makes it owns it. Now, the person who invents. So, IP ownership and inventorship is one of the greyest areas in IP law. Basically, if someone solves a problem, then arguably they're an inventor. So if you take it to China as a designed item and they have mold problems and they have to invent different things or come up with different solutions to that problem, then they can have some sort of inventorship rights.
Yep.
And typically what they do is they'll file their own Chinese application that you won't ever even know is there. It'll be filed in China, and then when you try and leave to get it made somewhere else, they'll say, oh, you can't because we've got this patent on the way that this works. That's typically how it works. The way around that is to basically set it up at the start and say, you enter an agreement to manufacture this thing on my behalf for me. The solution to any of the problems that you face during that manufacturing or tooling process are all going to be owned by me. So you can enter those agreements, and provided it's one of those things. It sounds cynical, but you're set up for the divorce before you get married, particularly with Chinese manufacturers. If you get the agreements in place early, in writing, signed, then everyone's clear on what their rights and obligations are. And if you ever try and leave and you've got one of those agreements, you say, right, this is the agreement. The agreement says I own everything. If you filed a patent application for this thing that you've used to make my invention, then that gets transferred to me. And you've actually got something that you can use to lever that from them.
We have that agreement, but I will update that to modifications on tools might be included now. That's good.
It's one of those things. I mean, agreements are good because not only do you have the patent, but you've also got the agreement. So you've always got two tiers of protection.
Yes.
So
Excellent. All right, I'm just conscious of time here. We don't want to bore anyone, but
I crap on a lot.
No,
Sorry.
no, it's been great. I mean, everything we've covered has been really, really useful. I've learned things, and I've been doing this for a long, long while. So, patents in China are done. Provisional startup. I think this is, for me. I'll just put a little interjection here about the importance of patents. So, a lot of people say, even a lot of lawyers I speak to, patents aren't worth the paper they're written on, and some aren't. I look at some and go, they just aren't. They really are just an idea. There's no viable solution to it, and unfortunately it chokes up the patent system, and I almost think there should be a qualification before you can put a patent in. But anyway, that's a side issue. But the importance of patents from my end is if you're going to talk to a multinational and you don't have a patent, it's part of what you're selling. So if you have a nice strong patent, the first thing you do when you go and speak to a multinational is you wait 2 weeks while you talk to their attorneys and their lawyers and find out whether it's worth the patent the paper is written on. Luckily with your intervention and interaction, we've always had really good responses there, that this thing is bulletproof, it's a great paint, it's nice and strong, very broad, and it's partly to do with the area we're in, the first world stuff.
Yeah.
But it's incredibly important when you're talking about licensing to a multinational, you've got a widget, but the widget's only part of the story. The ongoing protection of that through a patent is as valuable, if not more valuable, than the actual widget itself. So
well, the guy that you're licensing it to, or potentially licensing it to, what he's interested in, you've got to look at it from his point of view. He looks at it and goes, well, okay, if I pay to license this and I put it in my stores, then my competitors are going to see it. If they like it, and there's nothing to stop them doing it, then they're going to copy it, and they're going to undercut my margin and make my license worthless. So it's in their interests that you have protection, because that's a part of what they're going to use to restrict the market for them. So it's, if you think of too many people in business only think about what's in it for me. When you're talking to someone and you need their input, well, what's in it for them? And for them, your protection is valuable because they can use it, or use it as a lever to restrict competition that they're going to see. That's the worst thing. Woolies doesn't want Coles to have the same product. That makes no sense, because then Coles can compete with them. So if they're going to sign something, they want the patent. And if you don't have it, they look at it and go, well, how serious are you about it?
Exactly right. Yeah. So that's the reason you do patent stuff. When would you? I mean, for me, I know the answer to this, but when do you not patent things? For me, I have to have a significant point of difference and a significant functional difference as well. Because if you're just doing something, in a similar way, you're going to be infringing, or there's certain things, and it has to be a functional aspect. If it just looks different, then it's design registrations or trademarking or copywriting. All those sort of things are really valuable still. A good trademark, good brand name, as Hamish knows, is very valuable. But there's certain things you wouldn't patent. In your opinion, and this might finish us off, because otherwise we're going to be taking up too much of a day, and also probably get into a really long. How long we've been going for? A fair while. 41 minutes. Okay, we're going to wrap it up. But as a summary, what patents do you and don't you recommend to patent? It's a broad one. But what wouldn't you patent?
When's it worth it? Worth it. That is, look, we get asked that.
Definitely stage it when what you do. I mean, you recommend that. Make sure you control your costs.
It's probably, look,
your abilities.
You patent. You should file, or at least think about filing patent applications for things that are going to create value for the business or for you. If it's not going to make any money, or potentially make money, or have value, make money is the wrong way to think, but if it's not going to have any value, then don't do it. And a part of that value question is, as you just pointed out, how close are the competitors? If the competitors are close and what you're making is only very slightly different from the competition, then it may not be worth. We're talking $5,000 for a provisional, $10,000 for a PCT, thousands of dollars for national applications. You've got to make the cost benefit analysis. Am I going to get, or do I ever stand to get those thousands of dollars back? And if the answer to that question is yes, or potentially yes, then it might be worth it. If you're going to make more than that, or stand to make more than that, then yes. So that question involves, is it a viable product? Can it be made? Can it be sold? Are you going to make enough money out of it? Is your profit margin high enough? And is the market big enough to make enough money out of that to make it worthwhile?
It's almost like the old holiday situation. Are you going to? It almost comes down to, if it's not worth developing, it's not worth patenting. But there's certainly things, if it's just a visual thing.
But I'm sure there's complex situations too, where if you, like you said before, if you are able to patent something which is similar to a competitor product which is already on the market, can you decide to patent it just to be an annoyance to that company? And they may approach you and say, we really want to develop our product, that's something that we wanted to do. You're in the way. How much do you want to get out, to move out of the way?
And that happens. That happens a lot.
So you're not necessarily building value for yourself in terms of selling it, but you're getting bought out. So
I mean, there's still the value question. The first thing I ask generally to people who come in here is, okay, I don't really want to know what your idea is. How are you going to make money out of it? Because if you can't make money out of it, the best patent in the world is useless. It's a piece of paper that sits on the cupboard and does nothing for you. So unless you can actually use it to make money, don't even start. It's pointless. You're far better off. Some people come to us and go, "Oh, I'm going to spend potentially $5,000 here on the patent, or I could spend $5,000 on marketing." And you go, "Right, there's your decision. Are you going to make more out of that $5,000 spent on marketing, or $5,000 spent with me?" If your product's only very slightly different, marketing's probably going to be better than the patent, because the patent ultimately is going to be too narrow to be of any use. So it's all about balancing what you're going to pay versus what you are or potentially going to get. But a lot of people don't even think about how they're going to make money. The number of times I've heard, "Oh, I'm going to sell it to Bunnings," it's like.
And a lot of people think they're going to go and sell a patent too. I've never seen a patent being sold. I'm sure you have in your experience, but it's a very
that's
very
another.
rare
I was going to
thing.
ask that question.
Bunnings, you don't sell ideas to
patent.
Bunnings for a start.
Oh,
Bunnings,
no.
Bunnings rent you shelf space,
Yes.
and you have to fill the shelf space. And if you can't fill the shelf space and it doesn't sell, they cut you off. So you're not selling anything to Bunnings. That is not a viable commercialisation strategy.
And they'll tell you the price.
yeah, they'll tell you what you can charge.
Yeah.
Look, selling patents is the same. A lot of people come to us and go, "I've got this patent. It's I'm not doing anything with it. Where do I sell it?" A very difficult question.
Yeah.
There are places, particularly like the Australian market's not really big enough to buy and sell, have a platform to buy and sell patents. In the US, there are a variety of providers, but you've got to be careful. Normally they ask for a pound of flesh or your firstborn or something like that to sell it on your behalf. As in, we'll sell it on your behalf and then we'll take 90%.
Yeah.
So you've got to be a little bit careful with that as well. But 90% of some numbers probably still better than nothing if it's just sitting on the shelf.
Yeah.
So there's always, you've got to be harsh with them.
Yep.
You've got to treat them like a business asset. If they're not making you money, you either don't file them, or if you've got them and they're not making you any money, they will be costing you money.
Yes.
So you cut them.
Yeah.
You just kill them as soon as you can.
It's a hard decision.
Yeah.
We better wrap it up, but it's been fantastic. As I said, I've been in this a long time, and I've certainly learned a few things in this little interview, so hopefully other people have as well.
Yes.
But in the end, it's a bit like the development process that we use. Build everything on rock, do it properly or don't do it. The money can be spent on a lovely holiday, or it can be spent in patents, but if you can do the patent part of it,
You sound like you're getting into a travel agency, I think, Scott. It's Farley World Travel.
all about travel.
I like it. Oh, trademark infringement.
Thanks, Regan.
Possibly.
Appreciate your
Yes, thank you very
knowledge
much.
and sharing it with the audience.
No, man.
Fantastic.
You've been listening to Off to Market with Scott Farley and Hamish Chadwick.